Good morning, everyone, and welcome to another in the JBDC Virtual Biz Zone webinar series. The Virtual Biz Zone is JBDC's platform for empowering our client group during these challenging times. We've been hosting this series of webinars since April 2020, where we invite entrepreneurs and experts in particular areas to share insight on the changing environment of business in the era of COVID. We have so far conducted close to 100 webinars. Can you believe that? So far, some of the areas that we have conducted workshops in include research, marketing, managing business risk, business registration, the importance of record keeping, and tips on how to pivot your business to ensure continued growth, developing new products or services, or entering entirely new markets. My name is Sansia Campbell, and I'm the Public Relations and Events Coordinator at the Jamaica Business Development Corporation. This morning, we are going to continue our deep delve into research by focusing on managing corporate and customer data. As small businesses, data is critical in making business decisions, and our speaker this morning will share that with us. He is an attorney at law and founder and CEO of Design Privacy, Mr. Chukwuemeka Cameron. I hope I said that right. Let me remind you also that if you have missed any of these sessions, they are all available on our YouTube channel. That's at JBDC Jamaica, and we encourage you to subscribe and watch at any time. At the end of Mr. Cameron's presentation, we will facilitate a question and answer session. However, if you want to ensure that you don't forget your question, we encourage you to also type it into the group chat so that we can facilitate the questions post the presentation. So at this point, I will hand over to Mr. Cameron, who will be speaking to us this morning on managing corporate and customer data. It's over to you, Mr. Cameron.
Good morning, Sansia, and thank you for given me this opportunity to share with your members. I hope you are hearing me and seeing me okay?
Yes, we are hearing and seeing you very well.
Lovely. And I'd actually like the title of this presentation, Managing Your Customer and Corporate Data. The reason why I like it is because we now need to understand that what we understand as our customer, as our corporate data, which entails a lot of our customer data, is no longer our data. And there's a pregnant pause there for a reason. So I'm going to repeat that. Our customer data that makes up our corporate data is no longer our data. The reason why I say that is that our customer data belongs, well, and when we speak about customer data, I'm equating that with information about the customer, information that can be used to identify the customer. Under the Data Protection Act, that's known as personal data, and it is a customer who owns their data. So I'm going to start this morning's presentation with an analogy. So flowing from the NIDS decision, and that is where the opposition took the government to our constitutional court and challenged whether or not the right to privacy was breached by the compulsory imposition of a duty to register, and not only register, but register and also register certain biometric data. Our Chief Justice found, and this is where I get into the analogy, and then I will go back to the legal terms. What Chief Justice basically said coming out of that decision is that personal data must now be viewed as crown jewels. And you, you, the business person, you do not own those crown jewels. So, right, you now have in your possession crown jewels. Those crown jewels do not belong to you. Those crown jewels belong to the persons who own them, your customers. You, however, are custodians of those crown jewels. And if you are going to do anything with those crown jewels, it follows that you must have permission of the owner to treat with those crown jewels. And as we move forward through this presentation, and after you leave this presentation, if it's one thing I want you to remember, is this analogy of crown jewels and personal data being crown jewels. If it is, you are able to concept and treat all the personal data that you have in your business as crown jewels, you would be well on your way. So what the Chief Justice actually said coming out of the decision was that we now have informational privacy rights, and those informational, and once anyone uses your personal data without your authorization, you are more than likely breaching your right to privacy. Prior to now, the only right to privacy that most of us appreciated, which was consistent with what the Constitution provided, was that no police can come and kick off your door without a search warrant. Even with a search warrant, he's not necessarily supposed to kick off your door, but he cannot conduct a search at your house without a search warrant. And if he were to do so, it would be a breach of your right to privacy. What he's required to do, he's required to go to court, present information to a judge, setting out the basis upon which he believes he can find certain material at your house or place of abode, and get the judge or persuade the judge to issue a warrant. With that warrant armed in his hand, he can now present himself at your door, present you with a search warrant, and lawfully conduct a search of your home. So, while he will be restricting your right to privacy by conducting the search, it would be a lawful restriction of the right to privacy. Because once you have a constitutional right, the only way the government can or anyone can lawfully restrict that right is if it is done in accordance with the law. That is exactly how the right to privacy works as it relates to data protection. The Constitution has said, and the Chief Justice has said, look, if you're processing any personal data without authorization, more than likely you are breaching the right to privacy of the Jamaican citizen. What the Data Protection Act has done is the very same thing the legislation has done for police officers. It allows businesses now to follow certain standards that have been set out in the Data Protection Act to lawfully process data. So if you process personal data outside of following the standards set out in the Data Protection Act, you are both in breach of the Data Protection Act and in breach of the right to privacy that has been set out in the NIDS decision by the Chief Justice. So what is personal data? So personal data is any information that can be used either by itself or in conjunction with any other piece of information to identify an individual. And if you are thinking to yourself that this definition is very wide, you are correct. Let me give you an example. If it is I were to ask all of you, please tell me who is a short man who used to run downtown, and it was often said that he actually used to run Jamaica. Could anyone hazard a guess as who the short man is? Anyone care to hazard a guess as who which short man I'm talking about? Um,
Persons can raise their hand and I will acknowledge. Charlie wants to, Charlie, I'm gonna unmute your mic.
Good morning.
Yeah.
Persons would probably say Dodos.
And persons would probably be right.
Yes.
Yes, somebody else in the chat said, now in America, jail. So we know it's who that.
Correct. So although that was very wide and very vague, you realize that given the context, you were able to identify who I was speaking about. The point being, if it is you are to receive a business card with short man who used to run downtown, and you are put that in your top drawer, in the left drawer in your office, and you are able to tell somebody, hey Andrea, please go to my office and look in the top drawer and bring out that business card, Shortman business card. That is personal data that is subject to the act. Remember the definition I gave you? Any information that can be used by itself or in conjunction with any other piece of information to identify someone is considered to be personal data. So it extends beyond just your name, your email address, your phone number, your IP address, your MAC address, your driver's license. It extends beyond all of that to any information that can be used to identify someone. So when we're having this personal data discussion, that is the first place you want to start. Wait. So if you find yourself engaged in a personal data discussion, the first thing you need to say is stop. Hey guys, is this personal data we're talking about? Does this fall subject to the Data Protection Act any at all? Before you get into a heated discussion about what I must do or what we need to do. And that is why I actually like the title of the presentation, so I can make that distinction. So customer data is as well, as long as either your customer data or corporate data can be used to identify your customer, it must be regarded and treated as personal data, and as such is subject to the Data Protection Act. Let me put this in the wider European context as well. So the first impression or the first response to legislation such as this, and you guys may have heard about it and have quite correctly started to work, okay, so what does this mean for me? This mean again, have to find some more money to spend and it going mash up my business. I might as well I stop, lock up shop. Halfway into a lot of my presentations, that's the feedback that we usually get. I'm happy to report though, by the end of the presentation, they now see the legislation as an opportunity and not a reason to lock shop. Why the Europeans implemented the GDPR, which is a General Data Protection Regulation, which is similar, which we have followed, is to facilitate the exchange of personal data. Prior to the GDPR, you did have several pieces of privacy legislation, but they all had different standards and different requirements. So to move data between European countries, you had to apply with this regulation, you had to apply with that regulation, and that did attract a lot of cost and a lot of transactional costs. To remove those all that friction associated with moving data across Europe and commercializing it, they said, okay guys, we need to make it easy and seamless to share data. And that is the same impact that our legislation has. It is actually supposed to make it easier for you to leverage personal data in your business. It is not a restriction as to what you cannot do. Remember, just like that police officer, it allows the police officer to conduct that investigation that otherwise he could not have done so lawfully. So it's the same thing in your business. Complying with the legislation allows you to effectively conduct your business, and given the challenges that will be faced and the reluctance that people will have to implement it, it will actually give you a competitive advantage. As a data protection officer that represents a few entities in Jamaica today, I can tell you one of the things we are looking at for a company that is trying to become data compliant, to part of their process is to ensure that any service provider that they work with, that they are also compliant. Because if it is we are giving our crown jewels to a third party such as yourself that has a special skill and we are using your services, we have an obligation to our clients to ensure that anybody that we give our crown jewels to are also have the adequate secure technical and organizational measures in place to protect the data. So even if you guys might be thinking, hey, this may not really apply to me, I'm just a small one-man shop, I'm not going to bother with this right now. If it is you offer services to any big company or any entity that is sensitive and attempting to become data protection compliant, they are going to require you to demonstrate that you have put adequate measures in place to protect the measures. So going back to the Data Protection Act and what the Chief Justice said or didn't say. So what the Chief Justice did not say, although he said we have this informational right to privacy, he did not break down what those rights were. So what the Data Protection Act does, it does four things actually. The first thing that it does, it actually sets out what those data subject rights are and details them. The second thing it does, it tells you how you are to treat with those crown jewels. Okay, you have these crown jewels in your care. This is how you must care for them. So it sets out 8 data processing standards that you must follow. So in creating the rights or setting out the rights, they didn't just leave the rights out in left field as some cerebral concept. You as a data controller, the business owner, has also been tasked with the obligation of ensuring that you enable those data subject rights. And you heard me just use the word data controller. I will get back to that. And finally, they have put up basically a watchdog in place to ensure that you are complying with the data protection standard processing standards and you're observing and enabling the data subject rights. So you heard me use the word data controller a while ago, and you have heard me use the word data subject. So the next thing is, if you're engaged in any discussion around privacy and data protection, these are some terms I would like you to drop, just to let people know that you sat through a presentation with Mr. Cameron and you know about what you're talking about. So there are 4 key actors and key terms that I want you to be conscious of. First one is a data controller. A data controller is anyone or entity that makes decisions around how personal data is used. It is that data controller that is subject to the operation of the Data Protection Act and has certain obligations to comply with. So My assumption is that all of you are data controllers here, and you may also be data processors. You can be both data controller and a data processor, but not necessarily for the same process. I'll explain that later. The second term that I want you to be familiar with, and that second actor, is a data processor. A data processor processes data on behalf of a data controller. Please understand that when I speak to processing personal data, it means looking at it, storing it, printing it. Any interaction with personal data is processing personal data. The other concept or actor that I want you to familiarize yourself with and be able to use is the idea of the data subject. The entire legislation turns around. Give me 1 second, please. Sorry about that. So the entire legislation turns around the data subject and the data subject's rights. So when we are thinking about data protection, data privacy, the foremost consideration must be the data subject and the data subject rights. Are we putting a data subject rights at risk? Not what is your business risk. Your business risk is if you breach the personal data, the privacy rights of the data subject. That's where you're exposed to business risk. And finally, you have your supervisory authority, which would be the commission, information commission. So those are the four major actors and terms that I want you to be familiar with. And once you drop them in any conversation, you will give the impression that you know what you're speaking about when we're talking about data protection. So we are going to quickly delve into what I said the legislation speaks to. Remember, I said the legislation speaks to data subject rights. It speaks to the, in addition to the data subject right, it speaks to the data processing standards that you're obliged to comply with. It also sets up that supervisor supervisory authority, and it also requires you to enable the data subject rights. So what are the data processing standards? Let's start there. So there are 8 data processing standards, and I'm going to quickly list all of them, and only going to, given the constraints of time, going to delve into about 2 or 3 of them. So the first data processing standard is that all data must be processed lawfully and fairly. Second data processing standard is that you must only process the data that is necessary. Third data processing standard is that you must only keep data for a limited amount of time. Fourth data processing standard is that all the data you process must be processed accurately and kept up to date. Fifth data processing standard is that you must enable data subject rights. The sixth data processing standard is that, well, I'm going to jump to the seventh. The seventh data processing standard is that you must implement technical and organizational measures. The eighth data processing standard is that you can only transfer data outside of Jamaica once adequate measures are in place to guarantee that the data subject rights have not been exposed. And I'm going to remember what that third data processing standard, that sixth data processing standard is that I have forgotten. Okay. The data that you process must be relevant for the purpose of processing. So let us quickly delve into at least 3 of them or 4 of them. So So far, there are a number of fundamental things I want you to take away from the presentation. One is that personal data must now be treated as crown jewels. Guard them with your life because they are not yours. They belong to the data subject. Two, there are four key terms that we want you to remember. So this is a third and one of the most important data processing standards that I would like all of you to be able to be in command of, and not even command of. It is just one question that I would like you to be able to ask yourself leaving this conversation. So the first data processing standard is that all data must be processed lawfully and fairly. You must ask yourself or your partner, what is the lawful basis for processing the personal data in our possession? Do we have a lawful basis for processing this personal data? And you don't have the luxury to make up an answer or think about it and come up with your own answer. The law sets out 6 specific lawful bases that you must fit within to comply with the law to say that you are processing data lawfully. And if we go back to that initial example of the police officer and marry the two together, you start to see how it's panning out. Remember, if the police officer came to your house, kick off your door, and conducted a search, it would be an unlawful search and a breach of your privacy. If it is, he came with a search warrant, it would have been a lawful search in accordance with the law. So the question in that instance would be, what is a lawful basis for you to conduct this search? Because using a search warrant is not the only lawful basis a police officer can conduct a search. If it is, he was in hot pursuit of a criminal and he saw the criminal run into your house, he can, without a search warrant, search your house for that criminal, alleged criminal, because he is in hot pursuit. So the question you could ask the police officer is, what is a lawful basis are you relying on to search my house? And he can say, here is my search warrant, or I just got on this scene. I saw a suspect running in this direction and I saw him run into your house. So he has provided you with a lawful basis for him to conduct that search. Similarly, you must provide for the data subject or the commissioner or yourself the lawful basis for you to be processing any personal data. So it could either be to fulfill a service or contractual obligation, or it could be to fulfill a legal obligation. The law requires you to collect certain data, for example, KYC information, or it could be by way of consent, or it could be to protect a vital interest. So an example of that is collecting certain medical data to protect yourself and your employees against the coronavirus. Or it could be for the administration of justice, or you can have a legitimate interest in collecting this data. You must bring yourself within one of those bases. And to say you're processing personal data on consent, and that is one of the lawful bases, that may very well be one of the weakest lawful bases, because if it is your entire business is predicated on processing personal data based on consent, as easily as consent can be given, consent can be taken away, and that can bring an end to your business. So you really want to take the time to understand what is a lawful basis outside of consent that you are processing the data. If you note, I said the first standard is processing data lawfully and fairly. Fairly means that the data subject has certain expectations as to how his privacy, his personal data will be treated. And more importantly, the legislation puts an onus upon you to notify him of how you are treating or processing his personal data. So you must notify him in writing of what data you're processing, how you're processing it, how you're protecting it, and who you are sharing it with. So those are the things you must do out of the gate. Going forward, you cannot collect more information that is necessary. So if it is you have a register at your office now, so there may be a coronavirus protocol that says you need to track everybody that's coming in. But you are collecting their name, their age, and their next of kin. If it is you are complying with that legal obligation to track who comes at what time, why do you need their age? Why do you need their next of kin? Yes, you may want, if it is you are doing a survey or you have you're operating a website and you want to collect some information, and so before they can download a white paper or access a webinar that you are putting up, you need to collect their name, their email address, their number, and their company. If it is the purpose of you processing their personal data is to give them access to participate in the seminar or the webinar, and that is what the data subject objective is. How do you justify collecting their their telephone number, their business that they work with? Yes, you may be interested in that personal data for marketing purposes, but the legislation speaks to that, and I'm going to speak to that is separately under section 10 that speaks to direct marketing. But unless if it is you want to collect that data for marketing purposes, you have to set that out separately and have a consent box that's unticked that says I would like to receive marketing material from you, and they have to tick it and opt into that, not opt out. They have to specifically select and explicitly indicate to you by way of consent that they want to receive marketing material from you. So for those who browse the internet, and you're looking for doing research and downloading white papers, you now see this a lot, where there are empty boxes that you are now required to tick if it is you want to receive marketing material or more information about the company. No longer are those boxes ticked for you, and you have to opt out. So the third data processing standard, and this one is also a fundamental one that all of you can yourselves implement or start thinking about. You must not keep the personal data longer for what is necessary. So if it is you put on a webinar, you collected this information, how long should you keep this information? The Data Protection Act requires that you keep it, you have a stated policy for how long you would keep that information. You cannot keep information inevitably just in case. You must have a stated data retention policy. Data retention policies are usually driven by either the legislation, policies, or business requirements. I'm going to jump now and go to the seventh data processing standard, and thus you must implement the requisite technical and organizational measures to guarantee the confidentiality, integrity, availability of the data, and prevent any data loss, accidental loss or otherwise. That data processing standards also recommend at a bare minimum, all your data must be encrypted and or pseudonymized. As a small business, a question you may ask yourself, I can barely pay my staff yet you're talking about, or pay myself, much less you're talking about encrypting personal data. Office 365 has a lot of the data protection compliance requirements built in. So if you have one of the basic Office 365 subscription, as long as it's properly implemented, you already get the sort of encryption that is required. So what implementing technical and organizational measures means has been interpreted by several different standard setting bodies, and you have from what is a low level security measures to high level security measures. At a very minimum, all of you here that are processing personal data, specifically digitally, that you are required to have these things in place. But before I tell you, just want to make the point that the protecting of personal data is not limited to protecting electronic or digital information. Remember that business card that had Duda's name sit on it? Well, no, it didn't even have his name. It just had Sharpman, who used to run downtown. You need to ensure that that business card is properly protected as well. But for those who are that have digitized your things, your practices, your businesses, and you may even be saying, but I don't digitize nothing. Yeah, I'm sure all of you use a phone and all of you have personal data in your phone. And it's not only for social purposes, you use your phone to contact your customers, and that's processing personal data. So there are some basic things you must do if you're using a computer. You must, and this is called Cyber Essentials Plus. You must have a firewall in place. You must ensure that you update your anti-malware and antivirus software. You must ensure that you update the patches. So when Microsoft sends out ready for update, you must update it. You must ensure that you have adequate user access controls in place. So when you go home and your child can jump on your laptop and access the same application that you are using, or in a bigger, well, where you have one or two persons using the laptop, only the right persons have access to what information they need. And you must ensure that it's your computer or whatever application you're using is properly configured. Those are the very basics, low level, that everyone must comply with in terms of implementing organizational measures. If there is a data breach, the information commissioner comes in and conducts an assessment, and you are found not to have done these very basic things, that is when you're in problems. So moving on to data subject rights. They are as follows. One, a data subject has a right to know what information you're processing on his or her behalf, and also have a right to demand, well, to access it, for you to give them copies of it. So just like if you give a jewelry repair store some of your jewelry to repair, and you have so much jewelry that you use in more than one jewelry store, you can, at any given moment, you can call them up and say, remind me, you have my gold bracelet, I don't remember who I left it with. As a matter of fact, can I get it back, please? I'm coming to pick it up today. In the natural course of things, you would imagine that he will be able to answer you right away, and when you're ready to pick up your things, you can go and pick it up. Similarly, so with personal data. So you have a right to access your information. You have a right to know what information they are processing about you and recover it, retrieve copies of it. As simple as that sounds, that is one of the most onerous parts of the legislation that companies have suffered from. So while you may be saying, okay, I hear what Mr. Cameron is saying, and I hear him talk about the supervisory authority, but I'm a small business. Is me one. No information commissioner is going to come and conduct an assessment with me when they need to be thinking about digital, they need to be thinking about flow, they have all these banks, all these other people before they look at me. not so. Remember, the entire legislation turns around the data subject and his rights. And remember, I also said that you have a duty. The legislation requires that you enable the data subject rights. So if it is the data subject were to make a data subject access request that the law gives him the power to do, the law also requires you to comply within 30 days. And you cannot comply, you can be exposed to criminal sanction or monetary penalties. And I have not emphasized the penalties or sanctions that you are exposed to. But as a matter of fact, you are exposed to 4% of your gross profit, or criminal sanction for breach of any data subject right or data processing standard. So going back to the first data subject right. So we have seen across Europe and in the Caribbean that once the data subject becomes aware of his data subject rights, that's the first thing that they do. Pick up the phone and say, hey, can I have all the information you have on me, please? So you have to know and be conscious of, okay, do I have a register at the front desk? Do I have CCTV that I collect their biometric data by way of their images? Do I collect their license plate number? Do I run their credit card? Do I communicate with them via email and telephone conversation? You have to be able to account for all the personal data that you're processing on their behalf and be able to recover it and give them copies of it. And that if you do not have a system in place or policy in place to facilitate that, that is very onerous and very challenging. The other data processing standard is that you have a right to object to processing. They also have a right to object to accepting data direct marketing material. Direct marketing is something I said that I was going to get back to. And this is, as small businesses, this is something that you guys want to embrace very quickly. And because you are small, you may be saying, boy, I don't have the sort of budget to do these things. But the reality is, because of your size, you are more agile and much easier able to implement it. Because once you get it, you just implement it yourself or pay for it to be implemented, and this is it. For a big company trying to change how they have done business for the past 10 years, it has to trickle down from the top, and a lot of people have to understand it, and it's just a whole different beast. So in relation to direct marketing, what the law legislation says is that you can only contact a potential client or customer on one occasion to get permission to send them direct marketing material. So if they are not an existing customer, you cannot call them or email them for the purposes of marketing your services. The only basis that you can contact them is to solicit their consent to accept marketing material. So that in and of itself has spawned many lead generation type businesses, because that will significantly impact on how we do all businesses generate leads in Jamaica today. But it's a very simple principle that must be followed. When we look at all the litigation and the cases coming out of Europe, this is a very common case, and all of you would be aware of receiving spam or emails from the telcos offering you this, and you don't know how them get the number and why they're sending you this, and you're very annoyed. It applies to you as well. You can't collect up some numbers from people and just call them, or emails and just blast everybody sending them your marketing material. So as much as we are annoyed with the telcos for sending us this information, it also applies to you. So the other data subject rights include the right to data portability. So just like how there's already data mobile portability, number portability in the mobile space, a customer can now go to a bank and say, hey, I no longer want to do business with you. But you don't need to tell them that. You just need to ask them to send your information to X bank, please. So those are some of the data subject rights that stand out. I'm going to quickly jump to what needs to happen when the legislation is activated. So where the legislation has reached now is that it has, and when I say the legislation, the Data Protection Act, it has gone through the lower house, it has gone through the upper house, and has been approved by Parliament. It has subsequently been assented to by the Governor General. That does make it the law of the land. For it to be a valid law of the land, however, it is necessary for it to be gazetted. When I last checked about 3 weeks ago, was not gazetted. I don't know what the state is today. There is a 2-year implementation period, transition period that is facilitated because that just contemplates the amount of work that needs to be done, both by data controllers and the mayor, what is involved in setting up this commission. So importantly, however, is that the minister has been given the discretion to implement the legislation in phases. So the only thing that is clear is that you cannot be punished or will not be punished or sanctioned within the next 2 years for any data breach. But whether or not there are other obligations that will be imposed is at the discretion of the minister. So what does the legislation require of you once the commission is set up? There are 3 things that you need to do. Everyone is required to register, all data controllers. So it's not sufficient for you to think, well, this legislation don't necessarily apply to me, I don't have time for it, and I'm just going to do my thing. If you choose not to register, you are exposed to a monetary penalty and criminal sanction. So you cannot process personal data unless you have registered with the Information Commissioner. Registering with the Information Commissioner means give them your particulars, what type of personal data you're processing, and identifying who the data controller is. If it is you require a data protection officer, you also need to register that data protection officer. A data protection officer is required if you're processing large amounts of personal data or sensitive personal data. Sensitive personal data includes information such as religion, medical records, sexual orientation, political views, whether or not you're a member of a trade union, that sort of thing. You are compelled to have a data protection officer. And that data protection officer's role is to ensure that you're complying with the data processing standards, be accountable to the commissioner, and be the liaison with their customers, data subjects. More importantly, and most importantly, and the work that needs to start now, is that on registration, you must file your data protection impact assessment. That involves identifying the personal data that you process. That involves identifying how that personal data moves through your business. Okay, you collect their personal data from a Facebook page, or you don't necessarily collect any personal data in your mind. It is only when they come and purchase a sale, conduct a sale, you process their credit card, that's collecting personal data. But you must track how the personal data moves through your business. Having done that, you need to analyze at each point through which the personal data moves, what is the risk? What risk is the personal data exposed to? as it moves through the Facebook page, as it moves through, as you put the information on the Dropbox folder that actually transfers the data to another jurisdiction. You have to assess the risk, and having assessed and identified the risk, you then need to remediate. You then need to put controls in place to minimize that risk. So you have to show them, register with the information commission of the fact that yes, we are processing personal data. This is what we think the risks are, and these are the steps we are taking to protect the personal data in light of these risks. And that, at a very, very high level, is what the Data Protection Act is all about and what your obligations are. What we have sought to do, because you would have to be specifically trained or hire someone to implement this, we have sought to start develop material that you can take, consume in small bites. And so we have recently started a podcast where every week we give you 3 tips that you can use to start implementing your data protection compliance program. And so you don't have to try and bite everything off at one time, because it may it may be an expensive exercise to get someone to do this for you. So we are just trying to, through this podcast, and the name of the podcast is Design Privacy Weekly, either on iTunes or Podbeans. You'll be able to find it, but you will be able to find basic tips that you can use to implement your own data protection compliance program. So please, I'm available to take any questions you may have now, and I hope I was able to at least leave this presentation with at least one new piece of information.
Mr. Cameron,
Yes, ma'am.
you're finished?
Yes, I am. Over to
Oh,
you.
I'm so sorry. I stepped away for a second. All right. Thank you so much for breaking down the Data Protection Act for us, because a lot of our entrepreneurs, I'm certain, we're not necessarily au fait with what happened with the Data Protection Act and stuff. But I wanted to bring it in a little further as it relates to how businesses operate and stuff. Let me see, I wrote down a question here that I wanted to ask you. When you were talking about the data protection processing standards, rather, you spoke about implementing technical and organizational methods. Can you break that down a little bit more for us as it relates to how businesses can implement these technical standards so that they are, doing things the right way, technical and organizational methods so that they are doing business the right way?
So I shared with you the basic technical measures that must be in place. That is one, encrypting all of your personal data.
Right.
That is a get out of jail free card, just to encrypt everything. So if you do nothing else whatsoever, encrypt all your data. I'm not saying that you may not be sanctioned or be subject to there may not be a data breach, but you will not go to jail. And the reason why, the risk to the data subject would be minimized. If it is, there was a breach, but you can't access it, personal data, because everything is encrypted. So that's the first thing and the most basic thing that must be done. And I'm sharing with you, if you can house your entire ecosystem in a Microsoft ecosystem, that offers encryption out of the box without any additional cost. So we don't have the excuses that we can't afford that. If you're operating a business, you must have a basic application. It may not be Microsoft, but Microsoft is a basic application. The second thing is that I shared with you some international standard known as Cyber Essentials Plus. Those set out basic technical measures that must be put in place. But when we speak about organizational measures now, it is that really speaks to one, ownership of the privacy risk. So as business owners, if you have a board or if you don't, some entity must acknowledge the this serious risk and own that risk. So in your monthly planning meetings or your weekly planning meeting, it must be documented somewhere that we recognize that this is a serious risk now, that we have to take it seriously. And you know, Veral, you're going to be in charge of this, or like how you attended the presentation at JBDC.
You
Or
know,
yes?
no, go ahead and finish your point.
Right. So I was just going to pick on Sasha again and say the same thing, because Sasha Gay came to this presentation. When she goes back to the business, she has to be responsible for taking this on. Having, so you can make the point you want to make.
Okay.
Sasha.
You know, as on a reel though, you were saying it in the while you were doing the presentation, and it is scary information. And I think it is important, it just goes to show the importance of when you collect data is one thing, but how you store and protect people's privacy is another thing. At JBDC, we usually have a lot of persons contacting us and saying, you know, we're doing this seminar or we're doing that seminar. Can you give us access to our to your database? And sometimes when we say no, people think that we're mean. But the reality is that the data has been collected for a specific purpose. We have said to persons, are you interested in receiving information from us as it relates to upcoming workshops, training sessions? This is prior to COVID, and post-COVID, our webinars and online sessions. And so we can't necessarily just hand out the information to the John public like that. So it is very, very important that our small business partners also note that when you collect customer information, as Mr. Cameron has said, this is crown jewels. You can't, you know, just leave it willy-nilly and it's not protected. Another important thing that you also shared with us, Mr. Cameron, that I wanted to highlight is the particularly online, the use of the firewall and the antiviral hardware and the access controls and updating our different programs that we use, Microsoft and all of those things help us to protect the privacy of our customers. And to tell you the truth, I never really know that. You know, I didn't know that.
Yep. So there's not much there's apart from when you get down to the technical part, it's not intuitive.
Yeah.
These are just things that you have to follow. So we have a few questions in the
Yes, in the chat. There are
chat.
some questions coming up in the chat that I just wanted to get some thoughts out there, you know.
So Sheena Brown said, tell us again the name of the podcast and where we can find it. So it's actually Design Privacy Weekly, and you can find it on iTunes or Podbean. So iTunes for iOS and Podbeans for Android.
That's
And
your podcast?
yes, please.
Oh, that's fabulous. And then Angeline Carr says you shared with us 4 key terms: data controller, data processor, data subject. She's asking if you could repeat number 4 for her.
You know what? I didn't see it, or did I? The supervisory authority, the
Yeah,
commissioner.
man, you did. I have that one written
Okay.
down.
Yes, please. And Angelique, everyone, please repeat numbers 2 and 3 of the requirements to process data. Number 1 is, okay, so the data processing standards are separate and apart from what you must do once the legislation is implemented. So the first data processing standard is processing data lawfully and fairly. The second data processing standard, and it may not be in this correct order, you must only collect the data that is necessary. The third data processing standard is that the information that you collect must be accurate and kept up to date. The
Yeah.
fourth data processing standard is that it must be relevant for the purposes for which you are collecting it. The fifth data processing standard is that you must enable data subject rights. So I hope I would have answered, you would have gotten the ones you didn't get.
All right, what I would like for you to look at for us again, Mr. Cameron, is the time bound. I know that you said that we can't collect data. We have to keep it for a limited time. Explain that for me, please.
So you must classify all the personal data you process. So on some occasions, so you may have collected data by way of your Facebook page for the purposes of registering for downloading a white paper or registering for a webinar.
Mhm.
Separate and apart from the fact that you run a credit card, separate and apart from the fact that every time you issue an invoice, you take the customer's name and number on that invoice. Those are three different ways that you collect personal data. You must have a data retention policy for each of those pieces of personal data that you collect. How long are you going to keep the names that you retrieved over from Facebook? How long are you going to keep the personal data that your security guard wrote down? How long are you going to keep the video recording of the person that walks into your store? So that is usually governed by one, legislation. As a business, you can be sued, and that is why it's important, everyone, to incorporate. Because if you are not incorporated and you are sued, you become liable for whatever loss or damages that the person is complaining about. Why that is relevant in what I'm saying is that you have 6 year a customer or a supplier or a person has 6 years within which they can bring a lawsuit. So the
Okay.
reality is you may want to keep some information, personal data, for upwards of 6 years to protect yourself in the case of a lawsuit in relation to a certain transaction. Or you may be processing financial data, and the law requires it that if you are processing financial data, you need to process it for, keep it for 7 years if you fall subject to any of the financial service regulations. So there are different external legislations that determine how long you may want to keep data for. But apart from that, you do want to look at what your business requires. So if it is you're collecting CCTV footage, the fact of the matter is that it may you may set it to rewrite itself every 2 weeks or every week. So you just can't let that run automatically. That must be documented in a policy.
Okay. What about archiving? How does that help in any way to protect information that we've collected over a period of time? So let's say, for example, the 6 years pass, but we don't want to get rid of the information. Can we archive?
You are in breach of the Data Protection Act.
Oh
You cannot
boy.
keep data indefinitely. What you can do is anonymize the data. And
Explain.
when I say anonymize the data, if it is, you can no longer use the information to identify an individual. You can then keep, you are no longer subject to the Data Protection Act. So for example, you just have a business card that says Sharpman. And when I just say Sharpman, you don't know who Sharpman is because everybody in Jamaica named Sharpman. So that can help you. So that personal data would have been anonymized by removing the part that says Sharpman who used to run Jamaica.
Yeah.
That information may well serve your business value because you may want to know the demographics of where this person lives. So you would want to be able to know that this person lives downtown or this person lives uptown. And we're moving into the age of big data analysis and artificial intelligence, and you must have a lot of data to process. And so and for those people that operate in the online world, you'd want to store this data now in your data lakes and your data warehouses. to get new insights into customer behavior and profile your customers. To do so, you don't need the name of the individual because you're not targeting an individual with your marketing program. You don't need his number. You can only keep those for a specific period of time. If you want to, you keep all of the personal data that has been generated over a period of time for future purposes. You have to anonymize it. No one should be able to look at a data set and have the ability to put the pieces back together to identify who is speaking about. That's what anonymization is.
Oh, wow. So if I have a question here that asks that if it is, for example, a government agency that I guess because it's a government agency should be compliant with whatever the legislation says. But what if an agency that reports to a particular ministry is demanding information that is 10, 11 years old? How do we treat with such data?
First question is, does the legislation, is there a governing legislation that requires you to keep that information for a certain period of time? If the
Right.
answer to that question is no, do you have a written data retention policy that you can confidently reply to the ministry and say, we have a data retention policy that we only keep this data for this amount of period. So sorry, we cannot assist you.
Wow. Wow, this sounds like a lot of stuff that a lot of organizations will have to do in order to become compliant with the Data Protection Act. Mr. Cameron, I want to thank you so much for having come and share with us this morning. It was certainly eye-opening information, certainly things that I never ever thought of. And I probably need to have a one-on-one conversation with you after this just to get some insight as it relates to how we operate even, because we collect a lot of customer data and we certainly want to ensure that we are compliant with what happens, what should be happening in our organization. A question just came in here from Bev Campbell. I know you touched on it, but please explain further what happens if one keeps personal data non-digitally.
So it is harder to protect and the risks are much greater. So if it is you have an appointment book or register that you capture everybody's name who comes in, you have to ensure that, is it the first question you can ask yourself after you establish that you're processing it lawfully? What's the exposure to the data subject? If it is, you go and sign in and you can see everybody who came to that premises and what time they came. And you can even say who they are going to. If you are going to your doctor, you don't want everybody to know, so you're going to this doctor and you know this doctor only speak with venereal diseases or that's a specialty, or you're going to your side woman or side man at a apartment complex and
Right.
then your name and they say who you're going to. You don't want everybody to be able to see that. And that's what privacy is. You want to keep certain things private about your person. Um, you have the same duties, they don't change. The only question you need to ask yourself is, am I collecting personal data? If you are collecting personal data, you are governed by the same 8 data processing standards. It does not change. It is just that much more harder to comply because it's in a physical format, but you have the exact same obligations. So if it is you have some, you're starting off, okay, you just learned about this legislation and you're actually moving, your business is growing and you can no longer operate out of this one office, but you now need to go to a bigger place. You cannot leave a box of files with all your customer information sitting down or just arbitrarily throw it away. You have a duty to protect it and safely dispose of it. So you have the same obligation. There are no less. It's
Okay.
just more onerous.
All right. All right. So thank you very much again, Mr. Cameron, for sharing with us this morning. Just want to remind everyone that this presentation was recorded and it will be available on our JBDC Jamaica YouTube page later on this week, in order to ensure that you ensure that you see it when it comes out. You can just go to YouTube right now and subscribe. At JBDC Jamaica is our channel. You'll be able to view sessions that we have hosted for the virtual biz zone, for our gift and craft virtual biz zone, or entrepreneur's journey, or in concert series, and all the other sessions that we have hosted since the beginning of April this year. So thank you very much again, Mr. Cameron. Thank you everyone for joining us this morning, and have a great rest of the day. Remember, we have another session at 1, so I'll see you then for those persons who have registered. Thank you so
Thank you very much.
Thank you so much, Mr. Cameron.
Bye-bye.
Bye.